We often hear about the great disjunction between the jurisprudence laid down by Indian courts on critical issues and the sensibilities of the Indian people. Sabarimala, Shani Shignapur, Tripur Sundari Temple, and so on. For whatever reasons, the courts seem to only come into conflict with the practices and rituals of the Hindu religion. It is happening so often that we must take a step back and reflect on its causes. To be honest, it is not too complicated. The system is run by people who operate in profound and sincere ignorance of the ancient civilizational thought to which the masses subscribe. And to be fair, we can't really put the blame on our lawyers and judges, for they are a product of an education system in which a student can complete his law degree without ever getting a whiff of the Indian ideas of justice. Why is it so? Well, that's because when India became independent, we adopted several features of the colonial legal system into our constitutional scheme. This legal system, established by the British, was anchored to rule the colony and keep the natives firmly under the boots of the colonial masters. Such a system can never be expected to be a template for governance of a culturally rich country like India. While these colonial aspects were only supposed to be transitory to ensure no disruption in the process of transfer of power from the British Crown to the Indian people, we remain stuck with them even today. Take, for example, the issue of decriminalizing homosexuality. For decades, the legal battle on this issue continued because even after independence, India could not orient its justice system away from Western values. On the other hand, Indic knowledge traditions have comprehended issues of gender and sexuality in varied contexts. The intellectual heritage of ancient India on this subject is reflected in ancient texts, rituals, law books, art forms, religious narratives, commentaries, paintings, and sculptures. However, our legal system continued to function in oblivion to this reservoir. As is evident from the previous example, the colonial system also brought within its sweep the jurisprudence, logic, reasoning, and practices which originated in the West. That in itself is not a disqualifier. The problem is that these ideas till date have not become integrated with our ideas of justice, living, and governance. We are still trying to cope and failing miserably at that. On the other hand, the Indic knowledge on these very subjects is rich in content and vast in its breadth. Indic jurisprudence encompasses various facets of procedural and substantive justice. Theories of justice in Indic jurisprudence are highly developed and can seamlessly be integrated with our legal system. In addition to justice, logic was a distinct discipline in the traditional knowledge system of India. It offers methods to conduct inquiry into different layers of truth, including the most subtle layers, which is difficult to unravel. Ancient Indian texts also provide a systematized method for conducting discourse or inquiry into truth, Vada, which is critical for the growth of any knowledge system. However, this knowledge has remained dormant and irrelevant due to the sheer ignorance of policymakers who remain in awe of anything spoken by the white man of a bygone era. This brings me to the issue of language. India is a multilingual country, and it is difficult to explain why, even though the Constitution recognizes numerous official languages, English continues to be used almost exclusively as language of record in Indian high courts as well as the Supreme Court of India. In a more legalistic parlance, the official languages do not enjoy parity of esteem. What does this mean for those Indians whose home language is not English but one of the other official languages? It means that without competent interpreters, we risk injustice in our courts. Thirdly, the worst tragedy has been the absolute displacement of traditional and customary law from the modern Indian legal system. That's why, whenever any issue related to the interpretation of customary laws comes before the courts, we are handed down an interpretation which is at complete variance with our living. We are compelled to believe in the spectacle of constitutional justice, which should ideally derive its authority from the people. Such an understanding is nothing but an unfortunate byproduct of colonial legal education. It is even more unfortunate that any idea with roots in pre-modern constitution phase is dubbed as obsolete and archaic. Take, for example, the attitude of our courts towards traditional justice systems. Our legal system has rejected speedy and efficient systems of administration of justice as it puts constitution at a hallowed pedestal to be worshipped by the citizens. For too many years, everyday Indians have been subjected to the terrifying ordeal of dealing with the legal system of India. It is time that we imagine, prepare, and build a legal system for Indians. This is Prashant Singh for Upward.